Good morning, everyone. Today is Wednesday, 10 a.m. Mountain Daylight Time, and that means just one thing, that we're back again with the Canadian Immigration Live Q&A. Today, we have a little bit different arrangement. It's not me, Mark, and Alicia. It's Alicia, I, and someone else. And you will know who that person is in just a couple of minutes. So again, just to remind everyone, we do these live Q&As every week on Wednesdays at 10 a.m. Mountain Daylight Time, where we try to answer your questions without giving you individual legal advice so that we don't get in trouble as lawyers, but we try to help you navigate the immigration process in Canada as smoothly as possible. And so we always encourage that you leave your comment, leave your questions in this live chat on your right side of the screen if you're watching on a computer or on your phone. We absolutely love to see where you tune in from, and hopefully this live Q&A will be very helpful to many of you because you will get the answers to the questions that were important to you specifically. Okay, so we will be waiting for more people to pile in, and while we're doing that, Alicia, how are you doing?
I'm doing well, Igor. We're looking at the end of summer here, so tail end of summer, and yeah, it's been it's been a tough time, I think, for a lot of clients because many people have their work permits coming to an end, and they're trying to figure out what do they do? Did they go home? What are their chances for PR? They're looking at trying to maximize their points under express entry, and so many of my clients now are meeting the end of their work permits. And so they're deciding, well, you know what? I got my 2 years of Canadian work. I'm going to go home. I'm going to get my year of foreign work. I'm going to try to work on my language skills, maybe learn some French, and see if I can, in the future, get a round of invitations through express entry because it's so competitive right now.
Mm-hmm, mm-hmm. Yeah. And Alicia, we have a couple of questions, not a couple of questions, but a couple of shout outs. So Adolfo says hello, hello to you. My favorite nickname of all here, Boomer Elbow Dude, Mr. Burns. Okay. Hello, good morning to you. And this person is tuning in from Kelowna. And we also have this comment from Nash. And we'll talk about that in a second because that's a huge update that everyone needs to be aware of. Okay. And then just to remind everyone, we are Canadian immigration lawyers. We work at Holthe Immigration Law. Our website is holthelaw.com, as you can see at the bottom of the screen. And you can also check out our courses and our podcast and subscribe to this YouTube channel for free information at canadianimmigrationinstitute.com. All right. Alicia, as we've mentioned at the beginning of this live Q&A, this live Q&A will be a special one because we have a special guest, and I'm really excited to introduce Esther to all of you. Esther, how are you doing? Can you hear us?
Hi, Igor. Good
Hello.
morning, everyone.
Good morning.
I'm doing well. It's bright and sunny here in Lacombe today, where
Mm-hmm.
I'm speaking from, and I'm happy to see you again.
Yes, same here. Same here. So we've been working with Esther for almost, like, I think it's over a year. Is that correct, Esther?
Yes.
Okay. So Esther was our special client, and um, she is a sister of the person who was applying to come to Canada on a study permit. And we had some challenges, and perhaps this story will be very interesting for many of you who are dealing with the same challenges. And Esther, can you shed a little more light on what challenges I'm talking about here?
Yes. So my sister applied for a study permit to study in one of the universities here in Canada. And we suffered a number of setbacks. She was refused a number of times. And so after many refusals, I remembered that I had been listening to the Canadian Immigration Institute YouTube videos. I had been following Mark for many, many years, even before I became a permanent resident myself. And so I was like, well, I think that Holthe Law can help me. So I contacted Holthe Law, and I was amazed at. I already had a lot of positive reviews about Holthe Law, but the reception, the communication was just incredible. They listened to our problem and provided possible solutions, which we worked together on. And finally, we had to go for a judicial review. And there were times that it was very, very difficult because we were running late, timelines were tight, and it looked like it was not going to be possible to make it at least for the school year that the applicant was supposed to be here in Canada.
Mm-hmm.
Um, Again, Holthe Law, and we worked with Igor. Igor was able to provide solutions. We were able to get the university to give a deferral, not once, but twice.
Mm-hmm.
So thank you to that university. Awesome, awesome client experience there as well. And Igor worked tirelessly on the file day and night, emails here and there. Sometimes I was wondering whether he works after office hours because
I
10
do.
p.m. and Igor is working on files. Because, yeah, the timelines were really very tight. And there were times that personally I almost gave up. I remember the way that Igor called and I was like, look, I'm tired. And he was like, do not give up. Look, let's give this a try. He was able to encourage us and get us to be at the same, shall I say, level with him. And I am happy to say that after several months of waiting and back and forth, the judicial review went through and the file was reopened, and we were happy with the end. So my sister was finally approved for her study permit and will soon be here to begin her program. So
Awesome.
thank you so much, Igor
Thank,
and Holthe Law. I really liked the collaborative process, as I haven't seen anything like that anywhere.
thank you. Thank you so much for your kind words. I want to give a little more context about the whole situation to our viewers. So remind me, Esther, when you came to our law firm, did you already have a refusal or you just planned to apply for the first time?
We had been refused at least twice.
Okay. So here's the story, right? So a study permit application refused, reapplying, refused again. Then Esther comes to our firm and we review the whole application. We identify potential ways to improve it and make it a stronger study permit application. We submit a strong application. I would not be hesitant to say that it was a strong application, yet it is refused again. And Esther, do you remember the reasons for the first refusal when you submitted the application with our firm?
The refusal reasons, the first two times were quite generic. It was, you do not have enough funds, you will not go back to your home country. Those were the main reasons.
Mm-hmm. And then when we submitted an application, they had concern with the funds. So they also mentioned, look, we see that you have a sister who's paying for your education and that you have a full scholarship and an allowance. As an international student, that's a very rare situation, right? Like when you don't have to pay anything essentially for your education. And that only happens like if you're a very bright student and your sister is this very bright student. She is awesome. She traveled to different countries. She advances the education of French language in her home country. She has been to France as an exchange student, and she's coming here to study French, right? And so she's this exceptional candidate, and Esther would be assisting her sister, essentially, right? But the officer says, you know what? I see that you've submitted like dozens of pages in evidence of your financial support, but still, somehow the officer was not convinced. And obviously, we challenged this refusal, right? We filed the application for leave and judicial review, and then we reach out with settlement to RSSC. And Esther, can you tell us a little bit more what happened after the first settlement?
So the first time we applied for the judicial review, I think we hadn't received the Rule 9 reasons. And so when you got the Rule 9 reasons, you advised that we withdraw the file and just do a new application.
Yeah, and
So
I
that
think
was what we did.
that was for the first refusal that happened before you came to our firm. But then when we filed a new application and that was refused, then we challenged the refusal in federal court. We received the Rule 9 reasons, and we essentially reached out with a settlement offer to IRCC. They agreed that, the refusal wasn't reasonable. Like, nothing in the GCMS notes and the Rule 9 reasons explain how the officer reached their conclusion. And so they agreed to reopen the application. So they reopened the application, and then they refused it again, right? And then we challenged the same refusal twice. And essentially, the biggest challenge that we had was, how do we make sure that your sister gets to Canada right on time and she doesn't miss the intake date? And so I remember, and Alicia, this is something like very interesting, because I will remember this file forever, because I was in Pearson Airport sitting in lounge at 5 a.m. finalizing the application record on the way to my vacation, and I had to take my laptop with me to Mexico, and I was like semi-vacating, but at the same time submitting this application through e-filing. And then the registry returned the application at one time. They were not happy with how we organized the PDFs, so I had to refile it again, and it was all a mess. But then we filed this application, and Esther, do you remember the date when they came back to us? Instead of giving us the Rule 9 reasons, what did they give us?
They gave us a settlement offer.
Yeah, so IRCC reached out to us.
29th.
Yeah, they like, we don't even give you Rule 9 reasons because there's nothing to see in those Rule 9 reasons. Let's settle. And this is very, very rare, right? And what's even more surprising about this whole situation is that we received the settlement offer from Department of Justice on a very special day. It was December 24th, right in the morning. And I was like, do you guys ever take vacation? Do you take time off? Or you work like tirelessly trying to cope with the number of JR files? And so that was a very happy Christmas present. And then we had another setback. And Esther, maybe you can talk about what happened after Department of Justice sent us their settlement offer.
Yes. So after the Department of Justice sent us a settlement offer, we were waiting for the file to be reopened. And finally, the file was reopened. But when the file was reopened, we were not given an opportunity to provide any updated documents. And so again, Igor reached out and let them know that was part of the settlement offer. So they finally gave us an opportunity to submit any updated documents we had. And again, we worked with Igor and provided them with some updated financials, especially. And then
so
there was
it happened. Go ahead. Sorry.
Yeah, you go ahead.
Yeah, and that happened in January. So the settlement offer came in December, and then only by the end of January we could provide additional information, right?
Yes.
Okay.
Yes.
And so what happened next? Yeah. Sorry, it's a delay in connectivity.
Yes. So after that, we did not hear anything from IRCC until March 12th. And on March 12th, they said they had received our documents and that they were reviewing it. From then on, dead silence.
And when did you have the new intake? Was it in September? September this year was the start of the program?
Yes, in fact, August. Her program starts in August, in 2 weeks' time.
Okay.
Yes.
And when did you get a final decision on a reopened application?
We finally got a final decision on July 31st.
So you can see it took 7 months for them to finalize a reopened application that they offered us to settle on. It's absolutely crazy. Alicia, have you experienced anything like this when it would take them 7 months to finalize the reopened application?
Yeah, and this is the thing that makes it so hard on judicial reviews, right? Many people don't understand that a judicial review is not an appeal, right? You might not get permission from the court to even continue. And in this case, Igor was really proactive, and he was trying to make sure to settle this before it actually had to go further in the court. And so that's a best outcome for everybody, except the problem with that is then it relies upon immigration actually putting that application back in the queue for processing. And so in this case, especially when you're looking at post-secondary programs, and some of them are, master's programs or higher level of education with scholarships and with, really rigorous academic standards, the school wants people to start right away. And so it's hard to get those deferrals. And then you have to get the provincial attestation letters, and, they have to hold that spot open for another intake. And so it's really difficult when once the matter, it's been settled, it goes back, it's approved for reconsideration, it goes back to IRCC, but then IRCC really needs to get their ducks in a row to actually process that file again. And when they drag their feet and it's 7 months, it's really hard for everybody because, that's your education and your opportunity that could be lost simply because of delay. And so I'm very, very glad that this is a happy story and that Esther's sister is actually coming and everything got approved in time.
Yeah, this is a very good story. I have another client who's dealing with a similar problem. The study permit was refused not actually long ago, probably like 3-4 weeks ago, maybe a month. And the intake is in September. And the problem with this program of study is that there is only one intake. So you cannot start your program in winter. And if you have to defer, you would defer for 1 year. And essentially, you skip the whole year. And what I see happening more often right now is that IRCC doesn't process your application until the time comes real close to your start date. And then they issue a refusal. And then good luck challenging this, right? If you want to challenge it, please, nothing stops you from doing this. But please make sure you contact your school, defer it for another year if the school permits, obtain a new provincial attestation letter, update all of your proof of funds, skip 1 year, sit tight, and then perhaps maybe you can reapply next year and get admitted to Canada. But again, the whole judicial review process takes so much time that if you have an unreasonable refusal very short to the start date of your program, there is not a single chance that you can challenge this, get the application reopened, and then receive the counterfoil in your passport, travel to Canada, and you cannot do that within a month. And so for Esther's sister, the situation turned out a little bit different just because we had a little more time. And it's very important that you reach out for help proactively when you still have time to challenge the refusal. And Esther, given that you've gone through all of this, do you have any other recommendations, maybe tips, maybe some words to support other candidates? Maybe you can share something that, having gone through all of those challenges, you feel like you would be doing different next time. Tell us about your overall experience.
Yeah, so I have, I'm sure I've told you this before, Igor. I am actually a certified international student counselor for Canada. So I've dealt with a lot of students in similar situations. I'm not an immigration lawyer, so I always tell them seek professional help early. A lot of the time, people seek help late. I thought I knew what I was doing, but IRCC thought otherwise, right? And so when we came to Igor, there were things he did a bit differently, and it resulted ultimately in a different outcome. So before you start your study permit application, it is very, very important that you seek professional help if you think you need it. A lot of the universities have international students counselors and what have you. But sometimes you just need that immigration lawyer to have that extra set of eyes. They see things that you cannot see. And so I would on any day recommend to students if they want to get it right the first time, because I have realized from my own experience coming to Canada many years ago and on my sister's own as well, that when you are refused once, it makes it even more difficult to get approved the subsequent time. And so do it once, do it right, and hopefully get your approval the first time. Holthe Law team is very professional, they are very reassuring, and they provide clear expectations from the get-go on what is required, what you need to do. They work with you on your unique case to ensure that you submit a strong application. And if it does not work out, they will challenge it like they did for my sister's file. I'm so happy that we came to Holthe Law, and I'm happy that the case ended the way it did because, yeah, the person is a funded student, and yet we had issues with proof of funds.
Mm-hmm.
And so for many out there who do not have scholarships, it makes it even more difficult.
Yeah. Well, thank you so much, Esther. Again, we're really happy with how it turned out. We wish that you would get a decision a lot sooner and that you could sleep easy at night, not having to worry about whether your sister's coming here or not. Because at some point, like this July, like early July, I was really concerned that RCC will just keep your file in abeyance, and not make a decision until your start date. And then they would refuse it, saying, "Oh, too bad, so sad, your program has already started. You cannot commence your program." And that could very well happen, even if the decision wasn't reasonable at first. Just the fact that they kept it without making a decision for a very long time could ruin this all for you. So on this note, Esther, thank you so much for joining us today. I don't want to hold you too long on the call. Perhaps you have other things planned for today. And yeah, thank you for trusting us, and thank you for sharing your experience with everyone.
Thank you for having me on board today, and keep up the good work.
Thank you. All right. Thanks. Have a good day. Bye-bye. Well, Alicia, that's it. That was my past client. Super excited to see her. Again, there were some connectivity issues, but we're really happy that Esther could join us and share all of this with our viewers. For those of you who are watching, who are considering perhaps submitting any kind of application to Canada, you want to make sure that you do it right the first time. And so the purpose of this live stream is not to promote ourselves, but to help you and to share the experiences of people who had to go through judicial review process, not once, but twice, who had to reapply, not once, but maybe 2 or 3 times. And persistency and your commitment and dedication pays off. But that's not enough, right? You have to prepare a strong application. You can be the most persistent and determined person submitting the same thing over and over again to RCC, hoping that one day you will land an officer who will be a little more kind. And that day may never come. I know some people would submit their applications for 10 times, hoping that sometime, like one day, it will get approved. Doesn't play out this way right now.
No, and Igor, I want to jump in too, because I was just watching the comments and people's questions on the side, and one of the questions that we sometimes get, and Emily P, I'm looking at your questions because I saw you were on last week as well. You asked, do we have a different fee after you get ITA? And the answer is no. We have the same fee after you get an invitation to apply. And the reason is because it is usually more work it is more work for us to go back and to try to figure out, what did you do when you initially created your Express Entry profile? What did you put in? And then we cross-reference it with your past study permit applications, your past visitor applications, your past PGWP if you are here on a work permit, all of your renewal and extension applications. And usually, I don't think I have ever had a client where they made their profile on their own and it was perfect. So when I went to the review stage, when I was hired, even if they already had an ITA, there have been a number of times where I had to go back to the client and we talked through it all together, and they shared their screen and we went through what did they put in each of their application fields. But there were significant enough errors in their Express Entry profile that gets locked in once you get your ITA that they ended up having to decline their invitation to apply because there was a significant risk of misrepresentation based on what they had said in previous applications and the mistakes that they had made in their profile. And so our legal fees are the same for Express Entry, whether you're starting out and you haven't done a single thing and you've never created a profile, or if you've created 10 profiles and you've had rejected applications, or you already have an ITA, because we need to just pull open the hood on that car and take a look at absolutely everything and what's been going on all those applications. It's actually easier for us. It's better if we can get involved earlier, because then you can head off and avoid a lot of the common things that people tend to get wrong, or that they just don't see, that they overlook, and they don't realize that there's inconsistencies in previous applications. Igor and I, we're kind of cross-examining people in a nice way, but we're thinking like an officer. We're saying, well, wait a minute, you said that your address was here, but you traveled over here and you've got foreign work and you've got Canadian work, so we need to explain all that. And if you didn't explain that in previous applications, you definitely need to correct it now. And so we're looking at that with a fresh set of eyes, but it does take a lot of work.
Mm-hmm. Yeah. Yeah. And some applications are more easy. Some applications are more complex than the others. And what I find to be the most challenging in our work is that when you see an application and you think everything is very straightforward, that's exactly the application where you will have a lot of landmines. And you have to be extremely careful. And when people come to us for consultations, they say, my application is as template as it could be. I don't have anything. And then you start asking them questions, and then you realize, okay, so this application may be simple, but whatever they've done previously may make them inadmissible. They may be found guilty of misrepresentation, or perhaps there are some other problems that you would never otherwise think about. And it's only through the process of questioning that we can determine those landmines and try to address them proactively, explaining everything to the officer. I remember I had a lot of Ukrainian clients who would come to me and say, I just need to extend my work permit. There's a special public policy. And when we tell them how much we charge, their obvious question is like, why, right? Like, how did you determine your fees, right? Like, and for Ukrainian clients, I have my own special rate because just I'm a Ukrainian myself. But those clients are the most difficult ones to deal with, because when they initially submitted their application, they put whatever in their application forms. And most of them have some things that needs to be addressed. Some clients, they don't have any mistakes, but perhaps they have an admissible family member, and we need to know all of that. And so that's why, like, for some questions that start with should I, can I, how do I, we always ring the bell and we direct you to book a consultation, because there are things that needs to be checked, and that's exactly what we do as lawyers. For people who are struggling trying to get their work permit or study permit or temporary resident visa approved, there are things that we as lawyers can ask you that can essentially make or break your application later on. It really depends on how do we put your explanation in the client information section, how do we explain your whole situation? And for some people who don't seem to have a shot, often we can find a solution. Not always, but often. And I remember there was a client from Iran, just a fresh graduate. He doesn't have lots of property. He doesn't have years of work experience in Iran, and he has a brother here in Canada. Likely, his application would never be approved if not for one thing, that he has an elderly parent that he cares about. And so it's only after we ask him like a ton of questions, and we actually dig into his personal background, that we could find this information, and we could make that a central argument in our application why he would be coming back to Iran. And so same for you, those who are watching, those 123 people. You can try to do it on your own. You can, if you feel like you need extra help, please make sure you reach out, because often we have solutions. All right, Alicia.
All right.
Are we ready for the questions?
Yeah, and I think we might need to do like rapid fire kind of
Yes.
round. I think Nash brings up a really good point, and yes,
Yeah.
that is a significant update that just happened where they announced that there is a change now with medical exams. So for express entry, for a long time, there was a temporary public policy that allowed people to use older medical exams, even if they had expired. And you could submit your express entry profile, your EAPR, if you got an ITA, you could submit that EAPR even if you didn't have a new immigration upfront medical exam. You can't do that any longer starting next week, August 21st. So starting August 21st, anybody who's submitting their express entry EAPR, so they received an ITA, they had a profile, they got their invitation to apply, they need to submit their EAPR, you must now have an up-to-date, valid immigration medical exam. And I've seen a number of questions about that, but basically, make sure that you go to IRCC's express entry page, medical exam. It'll link you to how to get your medical exam, your panel physician. So Igor's got it up on the screen here. So you want to book this ahead of time, because what happened a few times is that there are not every location has a panel physician. Most of the major centers have panel physicians. If you are in Canada, there are lots of panel physicians. But if you are outside of Canada, sometimes people actually need to travel to a different province or a different state within their country, or sometimes even to a separate country to go get their immigration medical exam with a panel physician. It has to be one of the people on this list. So people were asking, well, can you go to anybody? No, you cannot go to anybody. It must be an immigration panel physician. The list is on the website. You've got to book it with them, and they're doctors. And so depending on their caseload, they might be booking next week. They might be booking 3 weeks from now. And so you really want to be proactive and book an appointment as soon as possible. Once you have that medical exam, it will be valid for a year. So keep in mind that if you're looking at immigration, you might want to try to arrange things so that you will hopefully have a valid upfront immigration medical for you and all of your family members when you need to go and submit your EAPR.
Yeah. And Alicia, it's also very interesting here. So they say if you're applying under express entry, you must do a medical exam first. But then in the email that they sent to everyone, they basically said, as of August 21st, if you receive an invitation to apply for PR, you and your family members will need to complete an upfront medical exam. And so it creates this assumption that it's only if your ITA is issued after August 21st. Do you read it differently?
And maybe you can make that a little bit bigger, Igor, but I think it's anybody who is submitting their EAPR as of August 21st. So I think the trigger date is August 21st. So if you're submitting a complete electronic application for permanent residence under express entry, starting UTC time on midnight on August 21st, or as soon as the clock rolls over to begin the day on August 21st, then you have to have that upfront medical exam. That's the way that I read that.
And that's very important. So it's UTC time. So technically, if you submit your application on August 20th after 6 p.m. Mountain Daylight Time, that's August 21st. So make sure you don't submit your application without all necessary documents on August 20th, right? If the time is in UTC, is already August 21st. I hope that's clear. Okay, and Alicia, while we're talking about medical exams, we also probably want to talk about this temporary public policy allowing to be exempt from a requirement to complete a new medical exam. So essentially, if you are already in Canada, you're applying for permanent residence, and you completed your medical exam in the last 5 years, and there's no risk, or at least a low risk to public health or public safety, as per your medical report, you may request them exempting you from a requirement to complete a new medical exam. And essentially, they ask that you provide a copy of your old medical exam report form. And we also recommend that you write them a short letter of explanation explaining why you're requesting the exemption, and why you meet all of the requirements for this exemption. So perhaps this is the only change that we have since last live Q&A. And on this note, let's move on to the actual questions, and let's sift through those real quick. Okay, so we'll try to do rapid fire here. So Joachim, okay, is asking, can I use my PNP non-express entry temporary case file number to apply for a bridging open work permit when the acknowledgement of receipt is not yet received?
So Joachim, this is where, take a look at my bridging open work permit article that I wrote on our blog. So the problem with the bridging open work permit is that you normally need to have the AOR in order to meet eligibility criteria. So this sounds like a not good situation, but you might be in a pinch, because if your work permit is going to be expiring, you need to make sure that you file something to change or extend status before your temporary status expires. So the problem with a bridging open work permit, which is different than a bridging closed work permit, is that you must maintain temporary status. You have to be inside Canada and have valid status, and you usually have to have had AOR already received on that non-PNP our non-express entry PNP file. So if you filed through the PR portal, the problem, and this is a problem that my clients have run into, is that it's taking them 4 or 5 months before they get AOR. And in the meantime, they might be losing their status. So they might need to start looking for other options. Are there, can their employer support LMIA? Is there an IMP solution? Do they speak French? Can they do a mobilité francophone work permit to kind of make sure that they don't lose status? So there's a number of moving parts, but take a look at the article that I wrote on the bridging open work permit, and go take a look at the program guidance on A75 on the IRCC's webpage about bridging open work permits and what is required for eligibility.
Okay, and while you were answering this question, I was just looking through the other ones. So the next question would be from CE. Can a spouse follow later if the spouse is not yet ready to come as a dependent on a work-based express entry or PNP non-express entry? I'm just a little confused as to what exactly is the question here, how to go about it.
So CE user, yeah, Igor and I are both confused, because normally if you're coming as a dependent under express entry, then you are included as a family member. But you said a work-based express entry. So I'm not sure, are you talking about a work permit instead? Because there's different rules for work permits, right? There's specific rules for which family members of which kinds of work permit holders. It has to be high skilled. They have to be in certain tier 2 or tier 3 occupations, or a tier 0 or tier 1. So there's very specific rules on whether spouses can come if the principal applicant has a work permit already in Canada. And then there's other rules in terms of whether you include a family member in a permanent residence application, and that applies for PNP, non-express entry. It also applies for express entry. So lots of things to unpack there. We can't give you a clear answer because we're not sure exactly what you're asking.
Okay. The next question is from Laura. Are test scores supposed to be valid after receiving an ITA or throughout the processing time? Oh, this one is really important. We've seen some refusals when people misinterpret the rules.
Yeah, Igor, do you want to jump in then?
Yeah. So your language test report must be valid at the time when you submit your EAPR. So if you receive an ITA, your age is locked in, but everything else needs to remain valid, right? So your work reference letter needs to remain valid. If you have a job offer, it needs to remain valid, right? Like if you have a language test report, it needs to be valid at the time when you submit EAPR. Once you submit an EAPR, if something is expired, then RCC may come back to you and say, can you please update something, right? Like your medical exam. But typically it's only locked in when you submit an EAPR. I just recently had a refusal, a client with a refusal because she submitted her EAPR the day after she turned whatever 1 year older, and she lost 5 points. And so it took RCC probably 7 to 8 months to decide what do they do with their application, and ultimately they've refused it. And so now she doesn't have an option, and unless she leaves Canada, goes abroad, and works there for at least 1 year, accumulates foreign work experience in addition to her Canadian one, and only then her CRS score will be higher. But that she was like that close to getting permanent residence. Just submitted an EAPR 1 day later.
Yeah, and so really keep track of not only your language test, but also the education credential assessment. And those are valid for 5 years, but they're only valid for 5 years from the date of the assessment. So take a look at that. And same thing with language tests. There's 2 dates, right? There's the date that you actually take the language test, and there's the date of the test result. Make sure that you're counting your 2 years from the date that you actually took the language test, not the result date.
Okay. So next one is from Pookie. Hi, can the sponsored person travel outside Canada for a short period, 3 or 4 days, while waiting for the acknowledgement of receipt or for the first stage approval if the AUR is received?
Pookie, we are not touching this one with a 10-foot pole. You would need to book a consult because this is a really dangerous situation, right? Where somebody's inside Canada, we don't know what your temporary status is. We don't know which country they're a national of. We don't know if they have a valid visa in their passport, if they're visa required. We don't know which country they're traveling to. A lot of times people get in trouble if they try to go to the US and they don't actually have also a US visitor visa in their passport. Especially if you've filed an application. So it is always extremely risky if you're trying to maintain temporary status in Canada. As soon as you leave, that can actually cancel your application. So sometimes the act of leaving Canada cancels the application that you made to extend or change your status, or it can make you ineligible if you've submitted a permanent residence application and you don't yet have the acknowledgement of receipt on a permanent residence application. So very, very dangerous, risky situation. We would definitely recommend you reach out, book a consult, talk to us, because we need to know a ton more about what's going on.
And Alicia, on the same topic, we have a question from Adolfo. So can someone re-enter Canada with a valid work permit that expires the day after they return to Canada? They have already applied for the new work permit while they were inside Canada. And are there any risks of being allowed back as a worker? And what about maintained status? So this one is also very, very sketchy.
Yeah, red alarm bells. So Adolfo, if you are inside Canada and you file an application prior to your work permit expiring for a new change of conditions on your work permit, and as long as there's no misrep and as long as you meet eligibility. So what Mark and Igor and I have been talking about is people file these like placeholder applications or dummy applications where they just file an extension of like a postgrad application, but there's no underlying basis. That application 100% is going to get refused, and it's just a matter of time. Sometimes people do that just to buy themselves time, and they want to maintain status. However, the instant you leave Canada, you have lost your maintained status. So maintained status, kaput, gone. So be really, really careful. It is almost never advisable to travel while you are in that kind of waiting stage before you get a new work permit. Yes, there's a risk of not being allowed back inside Canada as a worker, because as soon as you leave, you've lost your maintained status and your employer can't employ you unless you get a new work permit. And so this is a risky situation and you might lose your job. You would definitely lose your authorization to work. Technically, and travel things depend upon your temporary intent. So if somebody already left Canada and it's too late now and they've lost their temporary intent, can they come back in? So they might need to now file a new application to change or extend status after they come back in if they're allowed reentry. If you can come back in before your work permit expires, immigration might let you back in, but they might have a number of questions about, your work permit expires tomorrow. What's your plan? What's your temporary intent? What is your employer doing to support your application? Have you filed another extension application? If you did, you've left the country, you now need to file a second application to change or extend conditions. So there's a lot of moving parts here.
Mm-hmm. All right. I wanted to pull up the question from Emily. She says, okay, last question, and that's a follow-up to her previous question. Is the application being prepared by a caseworker, or do you guys do it directly with us? Wonderful question. Wonderful question. And we have a lot to talk about here. Alicia, maybe you can tackle this one.
Yeah, so Emily, it's just us, right? So when you hire us, you get us. And Mark and I have been doing this for over 20 years, and we used to have different legal assistants and paralegals who would help us on applications. And it became really stressful because, as a lawyer, you're responsible for everything that a staff member submits. And so it's really, really important. And we understand how important every single line is, every single number is in somebody's application. And if there's a mistake, that could mean that that person's application gets refused and they have to go home or they lose their chance at PR. And so we don't have somebody who's a caseworker who's working on your file with you. You literally meet with us. Just we were talking about, Mark has now brought on Nicole. So Nicole's now going to be helping Mark and working with him as a personal assistant. So that's something that's great. That's going to help Mark a little bit be able to juggle all the balls that he's got going on and then he's juggling in the air. But other than that, when you hire us, you get us directly. It's not the most profitable model because it takes a whole bunch of time, right? For Igor to sit there and to go through and to grill you on all your personal history and past history and working through your letters of explanation. Same thing with me, right? So we go through that directly with you, which is why we charge what we do, because we're working one-on-one with you.
Yeah. And with our profession, you want it or not, you will sooner or later become a control freak, because you can lose your license or you can get penalized for whatever you missed on the application, or perhaps you didn't do your job properly. And so we never want to end up in that situation. So we spend enormous amount of money on different resources and tools to help us stay organized. And when we receive an email from the client, we respond directly. We would not trust it to someone else, because essentially it's our license in stake, right? And so when you send a question to our firm, you would get a response directly from a lawyer working with you on your file. If that lawyer is somewhere, like for example on vacation, someone else will respond to it, but you will not be getting responses to your legal questions from our support staff. Because first, we don't have much support staff. We have admin persons, but not paralegals. And there's a big difference and experience involved here. And yeah, we just worry that we may get in trouble if you get a wrong advice. So absolutely, we work directly with you, and that's the core of our model. All right. Alicia, this question from Alvin. Perhaps, Alvin, we need to know a little bit more about your situation, but in essence, he's asking, my full name is Alvin J, but my Canadian work contract only shows Alvin. Will this cause any issues? And that really depends on why you need this work contract. Like, do you want to prove that you have a job offer? Like, I don't even know why would you need a contract. Like, we need a little more details from you for sure.
Yeah. So in general, Alvin, for immigration documents, immigration is always going to use exactly what's on your passport.
Mm-hmm.
So most of the time, even if people don't use their middle names, if it's on your passport, so if it says Alvin J as your first name on the passport, that's how your immigration documents are going to be issued. And then you've got your last name, of course. Immigration also usually wants to know, have you used other variations of your name? Did you use a maiden name? Did you change your name at any point? But in terms of your contract, sometimes your contract with your employer, they might not know your full name, including your middle name, and they might just put a first and last name. As long as you understand what the terms of the contract are and they are doing that in good faith, then it hopefully ought not to be an issue if you are just getting your job contract. Sometimes, though, immigration might question things with that job contract if it's not done properly, or if the employer doesn't know your full name, or hasn't put your proper address, or hasn't properly gotten your consent. So usually you want to make sure that everything's as correct as it can be, but especially for foreign workers, so people who are coming under the temporary foreign worker program who need an LMIA, or people who are coming under the international mobility program, so it's LMIA exempt, like Mobilité Francophone, free trade agreements, C20 reciprocal work permits, intercompany transfers. Those ones have an employer portal offer, and the employer must properly put your name in that employer portal. So that's where you will want to make sure with your employer and their immigration lawyer that they have properly inputted everything into either the employer portal for that A number and the offer of employment, or under the LMIA, and that they've properly listed you as a named worker.
Mm-hmm. Perfect. And here, what I meant to say initially is that when you try to prove your Canadian work experience, we would provide a reference letter. Then you also need T4s, notice of assessments, or pay stubs. That's specifically mentioned on in the instructions on our RCC website. And sometimes what we do, we provide supplementary evidence, like your work contract. If your work contract says Mr. Alvin, then yes, of course, you can't use that because that's essentially a shortened name. But that's only a secondary document. But if that's the only document you rely upon, you probably should be cautious, right? All right. Okay, let's see. The comment from Batman. My wife got her outside Canada postgrad work permit approved in November. Her port of introduction letter expires on November 2027. We are expecting a baby, congratulations, due early next year. Can she travel to Canada in early 2027 to activate her postgrad?
Yeah, Batman. This is interesting. I mean, people are not normally outside of Canada when they get their postgrad work permit. We'd need to take a look at what happened, what your POE letter says, because you will want to be strategic. Because if she's trying to get her Canadian work experience, I don't know how long her program of studies was, but what is the maximum duration that she applied for on that PGWP? Because normally you apply for the PGWP and it starts right away, right? So when you get that work permit issued to you in Canada, your clock starts running and you need to start trying to get your Canadian work experience as soon as possible. So it's pretty unusual that you're outside Canada and they gave her an introduction letter. But what I'm worried about is that the clock is already running, and the end date of that PGWP. So when she comes, like let's say she comes in early 2027, they're not going to give her 3 years. If she was entitled to 3 years, she might only have until November 2027, and then she loses her postgrad work permit. So she might be losing her opportunity to gain high skilled Canadian work experience, and we'd need to know more about what's going on.
Okay. This one is from Iqbal. I have a Canadian master's degree, no foreign work experience, and I'm in a tier 3 job. My wife, who's on a spousal open work permit, works as early childhood educator in BC, has 2 years of foreign plus 1 year of Canadian work experience. For PR, who should be the primary applicant? Hold on, Alicia. Okay.
Yeah. So Iqbal, this is, who should be, how do we analyze your situation? What's the most strategic course forward? This is all stuff we talk about in a consult. So we'd encourage you to reach out, book a consultation, pick a time that works for you. You can take a look at Igor Mark's calendars. I'm away for the next 2 weeks. I'm going on holiday to Newfoundland with my family. So I will not be here for the next 2 weeks, but book with Igor or Mark. We just need to know more. The other thing that I will say is that you don't have to choose. Both of you can create an application. So both of you can create, well, a profile if you're looking at express entry. So you can each create a profile. So your wife can be the principal applicant on one, you can be the principal applicant on the other one with the other person as accompanying spouse, and just see, right? Because if she is an ECE, then it's possible that she might be eligible in a targeted draw. And if you have different sorts of work experience and different points calculations, and you guys might be different ages, there's no harm in creating two separate profiles and just seeing if one of them might get an invitation to apply.
Perfect. We have a little bit less than 10 questions to go because we'll try to wrap this up sooner. The good guy is asking, the reference letter given by my employer was in color, but not signed, so would be deficient. After reaching out again to the employer, they properly signed and stamped it, but sent back a black and white copy. Is this fine?
So we always recommend that you follow the letter of exactly what immigration wants, and most of the time they want it on company letterhead. So if the company letterhead was in color, then reach back out to the employer and say, can you please put this on a color copy of your letterhead if that's the way that they normally issue letters. So the problem with the first letter is that if it's not signed, it's not sufficient for immigration purposes because immigration says they want a signed reference letter. If the second letter that you got was signed and stamped, but in black and white and the normal letterhead of the company's color, then you need to go back and ask for it again.
Yeah. And it's interesting because for the police certificates, they specifically mention that your scan of your police certificate must be in color. They don't have that mentioned specifically for other documents in the express entry completeness check, but we're trained as lawyers to use analogy, right? When we don't have a rule on something specific, we look at what are the rules for something similar, right? And so we would always include only color scans.
Yeah, and it's true. It depends on whether the company letterhead is normally in color or normally in black and white. If it's normally in black and white, you might have an argument. But if the company letterhead's normally in color, IRCC does say on company letterhead. So
Yeah. All right. Okay. Laura is asking, can medical exams be done anywhere? So essentially, if you live in one country, can you travel to the other side of the globe and do your medicals there? Yes, we can.
Yep.
Okay.
It just has to
Easy.
be a panel physician.
Okay. Bilal is asking, what if my job title changes, but I always continue to work for the same employer? Will my employer have to write two different reference letters? Wonderful question. While you're answering, Alicia, I'll pull up the completeness check.
So, Glenn, this is something that we talk about in the course. The other thing that I'll make a pitch for the course. The course is amazing. So if you can't afford to hire us, please buy the course because that is a fantastic tool that's going to give you a ton of value and is at least going to set you up to avoid a lot of the common errors that people make in their express entry application. But one of the things that can definitely trip people up is changes in job title. And this is where I always want to ask more because it depends on what kind of work permit you have. If you have a closed work permit, if you're under an LMIA or an IMP, so LMIA exempt work permit, but it's employer specific, then changes in job title are dangerous, right? Because the work permit itself is going to say what your NOC is or your job title. It's going to say what your location is, your employer, and what the conditions on your work are. And if any of those things change, usually the employer actually has to go back and get a new LMIA or they have to file a new employer portal offer. If you are on an open work permit, so maybe you're a postgrad work permit holder, then yeah, you are allowed to change different titles and roles and you can work for different employers. But it is really important that if you hold different roles at the company, that the employer is specifying each of those roles and the duties within those roles, the time period that you worked there with that title, and what the pay and the benefits were for each period. So take a look at Igor's pulled up the proof of work experience, but it's really important that you have all those details. It doesn't have to be in 2 separate letters. It can all be in 1 letter as long as all of the information is there.
Mm-hmm. Mm-hmm. Perfect. Let's move on. He's special kid. Okay. While staying here in Canada as a visitor for an extended period of time would raise concerns when I submit my PR application.
It could, right? So it really depends on how you're here, why you have temporary intent. The longer that somebody stays here as a visitor, the more immigration is going to worry that they worked without authorization, that they were somehow working under the table, that they were not following the rules. And so, especially with work, it's really important that if you're here as a digital nomad, then you can show, hey, I was physically present in Canada, but I had remote work. It was 100% for a company outside Canada. I didn't enter the Canadian labor market. I didn't have Canadian customers. I wasn't paid in Canadian funds. You just want to be super, super careful about making sure that you complied with all the conditions as a visitor.
Mm-hmm. Wonderful. Alicia, we have some very controversial comment from Louise. As a Canadian citizen, Louise is concerned that everyone is complaining about delays when someone reapplies 10 times. It should not be allowed. Time for a huge reorganization and cleanup at RCC. Ooh, I'm very happy that we don't have Mark on this live stream, because Mark would explode and he would talk for like 10 minutes answering this comment.
So I think Louise is reacting to a comment that you made saying 10
Yeah.
times. And I think that was a little bit of hyperbole. You know,
Yes,
most people do not apply 10 times for a study permit. I don't think I have ever seen anybody who's applied 10 times for a study permit. So I think Igor was just being
over-exaggerating.
rhetorical, right? He was just using a turn of phrase. In terms of whether people can apply for different types of applications, there are so many different types of immigration applications, right? If you're applying to come as a visitor, that's one type of application. If you then change and you leave Canada, you come back, you decide to apply for a study permit, that's another application. Sometimes that study permit gets refused and it's not your fault because immigration made a mistake and you resubmit that study permit application. It's very, very rare that that happens more than 2 times. Very rare. Because most people just give up and that's the end of it. In terms of permanent residence applications, that's a whole different world as well, right? It's very hard to be eligible for permanent residence. There's like the stars must align, you must be very lucky, you must have all your documents in a row, and you must have the proper CRS score to be able to be eligible for express entry or for a PNP. You know, these are very competitive spots right now. And we know that the Levels Plan is reducing the number of permanent residents that immigration is taking for this year, for 2026, for 2027. And so there is definitely a downward trend. And the people who are now eligible for permanent residence tend to be superstars, right? They tend to be perfectly fluent in English, plus have some French, plus have a master's degree, plus be under age 35.
Yeah. And Alicia, maybe I can add here. So first, I certainly agree that it's a time for a huge reorganization and a cleanup at RSC. I think things need to change, and they need to change internally. How they put their priorities, how they determine the effectiveness of their processing mechanisms, whether they should rely more on AI, whether they should allow the officers to refuse an application without providing any written explanations in the Rule 9, in the GCMS notes, because what we often see is that officers would refuse an application just selecting bullet points, like from the checklist, without providing any written explanation. And the delays, they happen across the board, like with all immigration applications, and including in federal court. And that's another problem right now, because it's more expensive to maintain the court system than to run RCC department, essentially, right? And the court is overloaded with judicial reviews just because officers refuse applications without any reasonable explanations. And so that should not be allowed for sure, right? Like if the person is paying the fee for processing of their application, the officers must do their job properly as well. And
And this is one thing that I noticed, Igor. So now they're releasing officer notes, right? And so I had a consult with somebody who said, here are the officer notes. And Igor, the officer notes on a refused visitor visa application basically look exactly like the refusal letter with the checkboxes, just in a paragraph. They
yeah,
literally just put the same things, and instead of putting it with a, bullet points where you just click off which one you want, they just condense that into a paragraph. Like,
yeah,
not satisfied that there's ties to their home country, not satisfied the purpose of the visit is as stated, not satisfied that, there's enough finances. So I agree with you, Igor. I think there does need to be better transparency in terms of what are the real decisions for the refusal that IRCC is making on what basis.
yeah. And if you have a genuine temporary intent, and if you submit a strong application that there that doesn't have any reason to be refused, and the officer refuses us just because they looked at your application for 10 seconds and hit the refuse button, did not even bother putting their reasons, then that prompts people to reapply. If you have a weak, frivolous application, then when that's refused, you typically would not spend another $100 or $300 or whatever in processing fees just for the sake of reapplying. You would, especially if you're coming from another country, right, where you don't make Canadian dollars, right, or US dollars, where your local currency is a lot less strong, right? Those $300 make a difference. In some countries, that's like a monthly salary. And it's very frustrating when you submit a strong application and that's refused. Then, of course, you reapply or you challenge, and that creates those delays. So it's a very controversial comment. I agree with you. Something needs to be done, but not only on the part barring people from reapplying. They should not be barred from reapplying. What officers need to do is they need to do a good job. Okay. This question is from Laura. Any advice for undocumented individuals trying to apply for permanent residence? My first advice would be to book a consult. There's always something that we need to discuss when you are undocumented. First, we don't know where you are undocumented, in Canada or in any other country. How did you get to that country? Did you cross the border illegally? Were you caught? Were you arrested? Many moving parts, and we just cannot answer that question in more detail, except like saying reach out.
One thing that I would maybe you can pull up, Igor, is when do people need an authorization to return? So
Mm-hmm.
this is something that if you are inside of Canada and your status has expired, I want people to know that it's not a good idea to continue to remain here because of the immigration consequences, right? So first of all, it's a breach of the law. So you're not allowed to stay past the end of your authorized entry. And you might, if they find you, when they find you, and they issue you a removal order, there's different types of removal orders. And so if you found it, Igor, but it's just who needs an ARC. Yeah, and so this talks about how removal orders are enforced. What are the types of removal orders, right? There's a difference between a departure order, an exclusion order, and a deportation order. Most of the time, if you are issued these orders, you can never, ever come back to Canada. Never, unless you get an ARC, an authorization to return. It's basically special permission from the immigration minister to allow you to come back into the country, even though you were an overstay or even though you were issued one of these types of removal orders. In certain very particular circumstances, you might be able to depart and confirm your departure with CBSA prior to you getting one of these types of removal orders that would require you to have an ARC in the future. And so, there's different things to consider, but one of them is, are you going to need an ARC? And are you going to actually be issued a removal order that's going to negatively affect the possibility of you ever coming back or applying for PR?
Mm-hmm. Perfect. Before we wrap this up, we have one question from Isabella. I claimed points for my job offer and a worker expression of interest without noticing the wage requirement, and I understand that's for Alberta PNP. Now my boss has agreed to pay to give me a raise, so it will be fine when I apply. Will it be accepted? Can I continue?
So Isabella, it might be for Alberta, it might be for Ontario, it might be for one of the other PNPs that have an expression of interest system with a wage requirement. And this is something where you definitely need to reach out and book a consult because we need to know more. But in general, the timing is a problem, right? If at the time that you submitted that worker EOI, you claimed that you were eligible for a category and that you had a job offer, and that gives you a better ranking in the pool, but you weren't actually meeting the program eligibility based on prevailing wage rates, right? So normally it has to be above the median wage rate for your NOC for that location, and that's the same in Alberta and the same in Ontario. And you weren't getting paid that, and immigration will be able to see it based on your pay stubs because also your employer has to file tax documents and payroll documents as well. So this sounds like a definite problem, and depending on which province it's in, if it's in Ontario, of course, Ontario has moved to a new system as of, I think it was July 2nd, where employers now have to go and register that employer job offer. So they have to go in, they have to enter the job offer, and then you've got a certain number of days to go and put your worker EOI in there. If you're looking at Alberta, then there's nothing in Alberta that vets whether you're eligible for the application, but you don't want to get an invitation to or a notification of interest to apply if you never met program eligibility criteria, because you'll go through the whole process only to have them say at the end of the day, back when you applied, you inflated your score, right? You actually claimed eligibility, got a higher worker EOI score that you should never have had because you didn't have a job offer at the time where you submitted your profile. And also, depending on the circumstances, the officer could say it's misrepresentation, right? So not only are you not eligible, but we might try to bar you for 5 years or bar you from our PNP program for misrep.
Mm-hmm. Okay. Two last questions, Alicia, and then we'll end for today. Olavumi is asking, do you need a language test for a spouse when you apply for permanent resident if the principal applicant already has a good score in CELPIP?
So it really depends which kind of permanent residence application you're filing. So if you're looking at express entry and your spouse is in Canada with you, then yes, because it's going to drag down your score if you don't have your spouse's language test. If your spouse has decent language abilities, because when you are doing an application as the principal applicant on express entry, if your spouse is inside Canada, then you need to list them as an accompanying spouse, and the system will automatically ask for your spouse's language test. You don't have to provide it. You can just say they don't have a language test, but it is going to decrease your score significantly if you do that.
Mm-hmm. Yeah. And this last question from Sanchit, is a site COPER could be used to claim 15 points for relative in Canada if the relative in Canada does not yet have the PR card?
So, Sanchit, this really depends on whether you can prove that your relative is residing in Canada, right? Because that is one of the requirements in order to get the points under express entry. Not only that your relative is a permanent resident, but also that they are actively currently residing in Canada. So it really depends. Where is your relative? Can they prove that they not only have the signed COPER, but do they have a provincial driver's license? Do they have healthcare? Can you show that they are actively resident inside Canada?
Mm-hmm. All right. So that's going to be it for today. Again, thank you everyone who watched this live Q&A. We were really happy to see our special guest at the very beginning of the live Q&A. If you have not seen the part where we talked with Esther, you can watch this live Q&A in a recording, and we encourage that you go back and take a look at that initial part of the live Q&A. For everyone who left their comments and questions, thank you so much. We couldn't go through all of those, and we always are very restricted in time. And if your question wasn't answered, it might be because the question was a little too specific, or we just didn't have enough time to go through it. And so we encourage that you join us for the next live Q&A next Wednesday. Same time, 10 a.m. Mountain Daylight Time. And hopefully Mark will be back by then, so it will be all three of us again.
Except for me. I won't be here.
Okay. So Alicia won't be here. So again, it will be a two-person live Q&A. So thank you, everyone. We'll see you